Now data, when we say data, it is all about our personal data, right? It doesn't include any other data when it comes to data protection or data privacy. Now we talk about personal data. What is personal data? There is a definition under the Indian law. Of course, being a data privacy officer or a privacy professional, you are expected to understand not only the Indian law on data privacy or the privacy, but because of the scope with which we may have to work on various aspects of the data privacy or privacy as such, we may have to get to know the privacy law of other jurisdictions as well. I will touch upon why we may have to understand the privacy law of other countries and other jurisdictions as well, because of the cross-border data flow and the restrictions that we may have to keep in mind while carrying out the business activities and the company which we represent, right? Now, having said that, now second aspect or the second terminology is the word digital, right? Now, we live in a digital era, right? Especially post 2000, gradually things are moving from manual intervention to digital intervention, and most of our activities, both personal as well as business activities, are controlled through digital mechanisms. And therefore it becomes very important that we understand what is digital space and how do we process the data, or how do we handle the data in a digital environment. And then the last word which is used is word. Of course, we long back used the word Vasudhaiva Kutumbakam, right? The entire word itself is a family. Now, in a digital era, in a space where we 90% of our work is in digital space, there is no boundary as such in a digital business scenario. We do not have a national boundary for the flow of the data. It is cross-border, it is trans-border, right? Therefore, data can transfer from one boundary to another boundary without any restriction. There is no physical movement of the digital data. Digital data travels across the geographies without any restriction, and therefore we cannot restrict ourselves only to a country's or specific country's law, but as a privacy professional we have to understand bit of privacy law of each of the jurisdictions in which this digital data traverses, and then apply and understand the compliance requirement for these various data flow required in the context of business activities. No problem. Now let us try to understand, before we get into digital privacy law as such, how did we reach to this stage? If you remember, I think even when I was studying my masters, there was nothing like digital privacy law. We were not that much into digital world as such back in 2006-7 I'm talking about. It is only after 2000 we slowly started, gradually started moving towards the digital world. Now, what motivated or what helped especially India to move towards this digital world or digital economy? If you see, 90% of our business activities now are carried through digital intervention and not by way of a manual intervention. Now, what helped all these business houses to move entirely towards digital world is, I consider myself, it is because of three aspects. One is internet, right? I still remember when I was studying, monthly data limitation was only 2 GB, right? That too after paying some 300-400 rupees, right? I think now 2 GB is consumed in less than 30 minutes, right? Now, first of all, let us try to understand what is internet. What is internet and why was it so expensive and why was it not so affordable just 15 years back, and why it is so much cheap and why we can afford it so easily. Now, what difference that these 15 years made in making this internet available to everyone. Of course, I have not imagined when I was a student to use this internet so frequently. I know some of you might be texting through WhatsApp while listening to me, which we never did that. Of course, if we had an option, we would have done that. But we never did that. We did not have that facility to do that. Now, what is internet? And what transpired? This internet became, becoming so cheap in just 15 years. It did not just internet becoming cheap. It has become affordable, right? Anybody can use it, and it can be used in many ways. And you could have not imagined using internet in these so many ways just around 10-15 years back. Now, what is this internet? I know that there are master degree students here who have read through a bit of law as well as technology. Anybody can tell me what is internet? If you want to really practice data privacy, 50% of data privacy profession is about law. Rest of the 50% is about understanding the technology, about the system or the application or any other mechanism with which the privacy aspects are being integrated, right? Because as I was telling you, when we talk about the digital privacy, it is understanding the digital world and then applying the privacy law to the digital world. So definitely, without understanding and appreciating the technology or the concept of digitalization, okay, you cannot appreciate or apply the privacy law to the fullest extent. Therefore, every minute aspect of the digital world you need to understand, and it starts from understanding the term internet, because without internet there is no digital space. There is no digital world without internet. You just switch off internet for a moment, you imagine what happens to the digital world, right? There is no digital world. You are in a room. You are in a physical room. You just imagine for a moment that this room you are sitting, you don't have internet connection. It is no more a digital world. It is a classroom, physical classroom, right? So what is internet? Internet, I don't know how many of you know, internet is a physics. It's an applied physics. Internet is a wavelength. It's a frequency, right? For that matter, every internet, whether it is a Wi-Fi or whether it is a broadband, there are two types of internet, right? One, it is a Wi-Fi, which works without the wire. Second one is a broadband, which works with the help of a wire. One is called wireless. Second one is wirenet, right? What is this? Is nothing but a frequency. It is a wavelength. It is a physics. It's an applied physics. It's a wavelength which is made available by the government for you to use to communicate the data. So frequency is available in the nature, but there is a restriction imposed by the government. You cannot use the frequency of whatever the measure you want, right? Government has the full control and ownership of the entire frequency, which is a natural resource available in India, just like any other natural resource like coal, right? Any other mineral. Frequency or wavelength is also a natural resource. government has the full ownership as well as control over these frequencies or the wavelength. Now, government sells these frequencies to these telecom operators. That's why you have these telecom operators. Otherwise, you would have just used an apparatus and set the frequency for yourself and start using the internet by yourself without paying anybody, provided you have the necessary infrastructure to make a device which will capture the frequency, right? Now, back then, the purchase price of this frequency from the government by these telecom service providers was also very high. Therefore, the purchase price for you as an ultimate consumer was also very high, right? Now, what happened slowly, as and when the government realized the importance of internet, it reduced the price of the frequency or the wavelength to be sold by it to the various telecom operators, coupled with the infrastructure that is required to handle the wavelength, to handle the frequency, because frequency is what? Let's say, there is a frequency across the air, you just can't feel it, right? But you need to capture or send the data from one place to another with the help of this internet or a frequency. So there has to be one machine here, there has to be one machine over there, which connects to the internet here, transmits the data, takes that data to another device over there, and then downloads that data with the help of a device set up over there, right? Internet is a frequency where it converts the data into IP packets, transmit that data from one place to another destination, and then what it does, when it reaches the destination, it again converts that IP data, IP packet into a normal data and delivers it to the device to which it is connected. Are you understanding this technicality? It is just like transmitting any other data, right? But what you cannot see is how the data is getting transferred. It is all virtual, right? And it happens in a fraction of a second. The WhatsApp message that you send, right? It happens with the help of an internet. And how many fraction of seconds it takes for it to be delivered to the recipient? In a fraction of a second, right? Within a blink of an eye, it reaches. That is the speed with which an internet works, right? Go back to the previous slide. Yeah. That is the speed with which an internet works, right? And this is the main, phenomena which helped India to become a digital economy. In fact, most of the economies in the world have moved to a digital economy mainly because of the internet. I would say 90% of the credit for the digital economy or development of the economy in digital space goes to the internet. Without internet, there is no concept of a digital world. And therefore, it becomes essential for you to understand various technical aspects of the internet. How does it work? How it connects to the devices? Because it is just an hardware. It's a smart device, right? It's just an hardware. Without internet, you cannot call it as a smart electronic. It becomes smart only when it is connected to the internet. It can talk to you. It can open so many applications, right? It can do several other things. Okay, it can direct you to go to a destination with the help of a map. Okay, only when it is connected to the internet. Otherwise, it is just like a machine, which can do literally nothing actually, right? So it becomes a functional machine or functional device only when it is connected to the internet, and therefore much of the credit for a digital space goes to the internet. Now, when a device is connected to the internet, then what we as a business house started doing it, we tried to reduce the physical intervention or manual intervention in our business activities, and then we slowly started storing the data required for our business activities in an electronic form, right? Again, in an electronic form means what? In a device, in a machine readable form, what we call it as. There is a definition of electronic form under the IT Act, right? So, with the help of an internet, when we understood that 50 GB, of course, smallest of the cheapest of the mobile now comes with at least 64 GB of data, right? That means you imagine saving or storing 64 GB of a data. If you want to take printout of that 64 GB data and keep it in a shelf, okay, against putting that 64 data into a small chip, which takes what? How much space? Insignificant space, right? Now, because of this advantage of storing the data, which is more efficient for you to access, read, process, business houses felt very easy to store this data, whatever the information that is required for business activities. Instead of storing that in physical form, which is very tedious, they started storing it in a electronic form. So we slowly transitioned from physical storage to a electronic storage. Even if the lawyers, for that matter, if you go to a conventional lawyer, you may still see people printing, every mail, every case note and all that. But if you go to a topmost law firms, now the concept of taking printout has gone, right? We have started working in virtual office. In fact, during the COVID scenario, I still remember being a part of Cyrilla Merchant Mangaldas. We literally work from home, and the platform and the entire setup that was given to us was just like we are in office. Even though my laptop is in my house, I could not transfer or print out even a single email of office related stuff which is there in my laptop and start using for my personal use. No, you can actually literally create an office virtual setup sitting in your home, okay, yet maintaining all sorts of confidentiality, yet your manager or your employer ensuring that you will not steal the data. It is still possible. That is mainly because of the internet and because of the electronic storage. And how this is set up, just for you to understand the technology behind it, it is through what is called as, I know most of you are aware of it, it is through VPN, virtual private network. You are aware of it, right? The concept of virtual private network, right? Virtual private network is a closed scenario, closed group, where you are let in but you cannot come out unless you log out, right? So people, business houses started storing the data through electronic form. And last aspect or the factor which transitioned India from a physical world to a digital world is the outsourcing industry. Especially Bangalore is an outsourcing hub, right? We back in 2005 or 6, I guess, we started providing outsourcing services to various countries. Initially we started with BPO, business process outsourcing, and then we ventured into LPO also, right? Legal process outsourcing. So in BPO you include so many aspects of the outsourcing activities. In LPO you have only outsourcing activities with respect to legal matters. This outsourcing industry by nature itself has got a cross-border transaction, because what happened, because of the cost involved in certain back-end operations, these countries like US, Europe and some other countries outsourced a part of their work to countries which are relatively cheaper, like India, like Philippines, like Ireland. right? Now, with physical intervention, alone, or physical way of working alone, we could not have developed this outsourcing industry. And therefore, in order to facilitate this outsourcing industry, we moved into a digital space. So I would say, to begin with, in the year 2006 or 7, we ventured into, or we entered into the digital space mainly because of these three elements, which is mainly internet, and second one is electronic storage, and because we entered into, as a India, especially Bangalore, Karnataka, we entered into an outsourcing industry where we established a lot of companies to provide the outsourcing services to some of the developed countries like US, Europe, and other countries. Next slide. Now, fast forward, we did not stop at it, right? Now let us try to understand where are we now in terms of digital space, and then we apply how digital privacy law developed with the development of the digital world. Digital world as it was there 15 years back when we started, it is not the same today. It has developed a lot, right? You cannot even imagine how we transitioned from a baby, a baby digital world to what we are today, matured digital world. And I'm not saying that we are already reached the saturation. No, we have not reached the saturation. We are still evolving, but we have traveled a lot. Especially India, has traveled a lot when it comes to the digital developments or when it comes to the digital advancement. Now, we have understood what is data, privacy, digital and digital world. Now, second one is digitalization. Now, it has become a revolution. Similar to the revolutions that we had in the year 1990, right? Economic revolutions. Similarly, now we are within the process of digital revolution. It is called as digitalization. Similar to the liberalization, we are in the era of digitalization. We have started it some time back, but we have not completed the process yet. We will be there soon. We will reach the saturation for the digitalization, and then what happens is an amazing story. You can read so many documentaries about it. But we are still in the process of digitalization, and it is a revolution. We are in the process of revolution, right? Now, that process of digitalization has necessitated the enforcement of several digital privacy related laws, and we will soon see what are those regulations and laws surrounding digitalization. Now later on came the concept called big data. How many are aware of the term big data? Anybody knows what is big data? Data analytics, big data. Big data is it's a huge volume of data, right? You just imagine, I know if not one account, at least, if not more than one account, you maintain at least one account in Facebook, right? One your user account, one your page account, one another, some other account, right? From single account, enormous amount of data is being collected by Facebook. I'm just giving you an example. Imagine how many billions of users are there in Facebook. And you can imagine the volume of the data that is being collected by Facebook. Do you think that Facebook is giving you this entire thing free of cost without doing anything with the data? Twitter has now started charging you for blue tick mark, right? Facebook is not charging you. Do you think that it is doing a charity with your data, or do you think that it is doing charity by allowing you to browse through Facebook for hours together in a day, if not the entire day, right? How it is monetizing? It is doing nothing but it is monetizing your data. You just cannot imagine how it is monetizing your data. It sells your data, right? And do you think that you have not given your permission to sell your data? You have, but you are just not aware of aware of the fact that you have given your consent to sell your data to somebody else. That's why it becomes very important before subscribing to something, before activating some account in digital platforms. Please understand what are all the consents that you give to share your data with whom. It includes, if you list down from top to down, if you read, you have just given consent for everything. You have not kept any right for you with respect to the data that you share, because you think that using that platform is the ultimate thing for you, instead of compromising with your data, right? So this is how data is a big commercial property or commercial asset for these kind of companies. Of course, there are companies like, take the case of my company, right? I'm a pharma, I'm into life science services. My company is into pharma, healthcare, life science services, IT services, IT industry, right? We also collect the personal data, but in a different way. As a healthcare company, we provide patient support services. We are one of the reputed companies in oncology business. Oncology means to treat with cancer, right? Endocrinology is one of the main important functions that we do, which basically treats diabetes and all that, right? So we also collect personal data, health data, but to treat the patient. Without collecting these health data, this privacy data, we cannot treat the patient. We cannot administer the drug that we have developed, right? But there are companies whose main business is to collect this data by allowing the user to use their platform free of cost and then subsequently monetize the data. And I don't say that they are wrong at all the times. No, they are not wrong. They will inform you. They will keep you informed. They will ask you to write the consent. They will ask you to give the consent. Just that you don't have the, time and patience to go through and understand the implications that are arising out of the consent that you give. Okay? Just you give the consent and then face the consequences, right? What happened, you are aware of the Analytica case, Cambridge Analytica case in US. How many of you are aware of it? This is a current development, right? This is a very glaring example of data privacy violation. What happened in this case in US before the election, where Trump lost his election? In Cambridge Analytica case, they tied up with Facebook, and Facebook shared user data with Cambridge Analytica, and Cambridge Analytica is an organization, it's a political organization who sent targeted messages to influence the political decisions, right? And it was an intrusion into the privacy of the voters of US, right? It's a very famous case, and Facebook was penalized $5 billion for this violation, right? And therefore, big data is an amazing concept, but it has got its own advantages as well as disadvantages. There are companies which are using the big data in a legitimized way for legitimized commercial purposes. There are companies who, induce you to give consent to use that data for even unreasonable purposes and make commercial gain out of it. And therefore, if you are venturing into a digital space, before using so many platforms, so many account systems, make sure that whether it is really needed for you or not, and then subscribe to it, and you have control over allowing the company to use the data. It is not that you will simply, you can all the time you will have to simply give permissions. You can still say that use it only for this purpose. Do not use it for this purpose. Delete it after I inactivate the account. So just that you have to go to the settings and give those necessary controls or use those necessary controls, so that even if they are misused by the company can be held liable tomorrow, right? Next one is cloud. Cloud is also a very important aspect in digital space. Anybody can tell me what is cloud? Okay, so cloud is nothing but, just imagine you have put a rack over there, right? Rack to store your physical space, physical documents. Imagine a virtual rack. Cloud is a virtual space for you to host the data. Cloud is a virtual space for you to store the data, right? Google Drive, you are aware of Google Drive, right? If the space is not sufficient, I know most of you have minimum of 256 GB data, right? Just raise your hand, how many of you have got 256 GB data? Okay, good. Okay, how many of you have got 126 or 128? Okay, I can see many hands. Of course, 64 GB? Okay, everybody, most of you, right? So let's say that, I know for most of you 60 GB data is not sufficient, right? Or even for that matter 256 GB data is not sufficient. Where will you save the rest of the data? Let's say that from Netflix you want to download some 20-30 movies and watch later on while you are traveling to some tourist destination which let's say takes around 20 hours, 30 hours. Your phone storage capacity is not sufficient. Where will you save? You save it in a cloud atmosphere. There are many cloud service providers, right? One famous cloud service provider is Google Drive, which is there in your, similarly Microsoft also provides you OneDrive. OneDrive is also similar cloud service provider. So what I'm trying to say is cloud is a virtual space for you to store the data. Now with the help of a cloud you can do so many activities, and then when the concept of cloud came into picture, these companies started giving various services surrounding this cloud space, and that became an industry called cloud service provider industry, right? There are companies which provide you a cloud service provider. So let's say I'm a very big company. For me to have this cloud space, I need to have a lot of infrastructure, right? I need to have IT infrastructure. I need to have a very huge bandwidth. I need to have a couple of resources to manage those bandwidth and IT infrastructures. So what these companies have done, you don't have to worry anything. I will manage. I will prepare the cloud infrastructure. You just give that contract to me. You transfer your data with me. I will manage the data with you. So what you are doing? You are giving your data to a cloud company for storage of that data. So you can go to cloud, access your data, do whatever you want to do with that, and then come back and then close the work, right? But the moment you are sharing your data with somebody else, there is a risk of a privacy violation, right? Because it is no more completely protected, because you are sharing your data with somebody. Whether you are a company has also got a lot of personal data, getting transferred to a cloud service provider. For that matter, every day you are also transferring your personal data to so many cloud service providers. You have transferred your personal data to Google Drive. You have transferred your personal data to OneDrive, right? But as such, the invent of cloud and invent of cloud service industry has revolutionized the digitalization, digital world, and subsequently necessitated for the regulator to make necessary regulations towards protecting the privacy. Last but not the least, a very recent phenomena is a IoT, Internet of Things. Again, what is Internet of Things? Internet of Things are machine to machine, what we call it as, right? Very soon you will see, of course, Google, what is that? Alexa, right? Alexa is a best example for Internet of Things. What it does, with your voice command, okay, it will play a song, right? Now where is that song? How do you know that, where does that song come from? Right? Now you can, with the help of, in fact, I have configured my house CCTV system into my mobile. Right? Here itself I can see, I can see live CCTV footages. Who is walking across my streets? Right? Who is what is happening in my car basement area? Right? I can see what is happening, all the activities. And that is nothing but Internet of Things. The system CCTV which is there in my premises, my house, is connected to the internet. My device here is connected to the internet. Right? And the software that I have installed in both the devices are interacting with each other with the help of internet. Right? And thereby creating an ecosystem to do certain functionalities. That is called as Internet of Things. Right? Just wait for another 6 months to 1 year. You can control every smart electronics that you have in your house, from your mobile to your fan. Okay, sitting here 5 minutes before you want to reach, you want to switch on the AC because it's too hot. You cannot wait for the AC to cool your room. So you can press a button here. 10 minutes before you arrive, it can turn on the AC in your home, so that the moment you enter, you feel, it's a very cool thing, right? You can do that. You can turn on the fan sitting here only, right? It's already happening. In fact, I have not activated the Internet of Things, but I have already, when I constructed my house, it requires special devices, right? You need a special switch for that, which can interact with various devices with the help of an internet. I have installed all those switches and everything. Just that I need to connect to the internet, I am able to interact. Sitting at here, I can switch on everything. I can switch off my TV. If you have, if you fear that there is a theft in your premises, you want to make sure that, you want to give a feeling to the thieves that there is somebody at home. 6 o'clock in the evening, before it is dark, you can switch on few lights, select lights in your hall area, in your bedroom. Then 8 o'clock, 9 o'clock or 10 o'clock, you can turn off. Sitting here only, or sitting in Australia, you can do that. It happens with the help of Internet of Things, machine to machine. It is an ecosystem created by a concept called machine to machine or an Internet of Things. Right? And it can happen only in a digital world with the help of internet, cloud and digital apparatus or devices. Right? But all these facilities comes with a risk, and the main risk is risk of privacy violation. Right? Because you can see it. It doesn't mean that nobody else can see what is happening in your house. Right? No, it doesn't mean that nobody else can see what are all the activities happening in your. Best example, there you can prevent the physical stealing, physical theft, but you cannot prevent the online stealing. You cannot prevent hacking. You read so many things that this much of money has been stolen from my bank account. How do you think it happens? They will not do it over a period of in a fraction of second. First, they will hack your email. They take your password. Then they browse through your email communications. Most of you, including me, what you do, in order to remember our password, we just try to send the password to our own email ID. They read through that. And then they hack your bank account number. So they have got your bank account number, they have got your password. Then they try to call you. They log in your bank account ID, do some transaction, they need a OTP. They will call you, say that I am from this and this. You have received a OTP, can you give it to me? Without thinking anything else, you just share the OTP. That's all. Whatever the money is there in your bank account is gone. Okay? One, of course, it's a criminal offense, but before even that happens, what has been violated is your privacy. They have violated your privacy, they have stolen your data, they have access to your personal data without your permission, and then committed a crime of stealing your money. Right? Next slide, please. Now, having understood now digital space and all that, now let us come to, we are all lawyers, right? We will have to understand the law now, right? Now, I don't know, taking inspiration from Dr. Subramanya, he always goes back to our roots, right? He cites so many instances from our ancient days, from our culture, okay? And he always try to, connect that to the existing legal framework and existing jurisdiction, right? Jurisdiction. It doesn't mean that we did not have a, privacy law way back. We had certain restrictions protecting the privacy of the individuals, and those have been mentioned even in our Arthashastra, right? Arthashastra says that it prescribes rules as to how do we have to build our house in order to protect the privacy of the individuals, right? It says where the window has to come, what should be the gap between one house and another house. The Arthashastra clearly provides this. And why this was prescribed? In order to maintain the privacy of the people living at house. Okay, you may consider it a very basic rule to protect the privacy, but that was the origin for the privacy law of even today. We can actually connect. It doesn't mean that we did not have any policy or rules relating to protecting the privacy of the individuals. We did have. Similarly, even under Islamic culture, we had certain rules prescribing the privacy of the individuals. Then gradually it evolved. I know most of you are students of constitutional law. You know how right to privacy is dealt under Article 21, right? And the jurisprudence developed by the Indian judiciary. There are arena of cases dealing with the right to privacy under Article 21 of the Constitution, starting from Maneka Gandhi case, Auto Shankar case, right? And then you have phone tapping case is one of the best examples that you can discuss on right to privacy, right? So I will not get into too many details because you are already aware of it. That is how the privacy law evolved. But if you just think for a moment, this jurisprudence on privacy law revolved around the privacy of the individual, and it mainly concentrated protecting the privacy of the individual against the states or against another individual. That means protecting the privacy of one individual against the state or against another individual. It never thought, or the jurisprudence did not develop in protecting the individual's privacy against another business house or using the data for business activities. Now, when did this start? The protection of data or protection of privacy in business scenario came into picture only when the digital world concept was introduced in the year 2000 and subsequently, right? And you have Puttaswamy case. You are aware of this Puttaswamy case, right? It's a landmark decision in many aspects, because this landmark said that, of course, it reiterated the fact that privacy is a fundamental right. But in addition to that, it introduced another two concepts from the jurisprudence point of view. What it laid down? It laid down that the privacy has to be protected even by a private player when he is carrying out the business activities. That is where the judiciary intervened in protecting the privacy of the individual and his data to be utilized by the private companies like us. And secondly, what it this particular decision did? It asked the Indian government, it asked the legislature to make a specific and dedicated law, codified law on data privacy. If you see today, currently, the data privacy law, what we say in India is enacted under the Information Technology Act. It is not a codified law. It is one piece of a subordinated legislation. 2011 SPDI rules, what we call it as Sensitive Data Protection Rules 2011, is a subordinated legislation issued under the Information Technology Act. So there is no codified law. We have some few provisions protecting the privacy of the individual, but we do not have a codified law. Now, subsequent to Puttaswamy, next, let us try to understand. So, Article 21, the judicial intervention under Article 21, and then Puttaswamy, they all spoke about jurisprudence surrounding the privacy of the individual against another individual, or privacy against the state, protecting the privacy against the state. Now slowly from that, the jurisprudence developed from protecting the individual's privacy even against the players in digital space, in digital world. Now let us try to understand how that evolved. Now IT Amendment Act. IT Act, we know it came into the year 2000, right? But major amendment happened in the year 2008, which is an IT Amendment Act. This IT Amendment Act for the first time introduced a provision under Section 43A to protect the privacy of the individual for data stored in an electronic form. In other words, it laid down the provisions for protecting the privacy of an electronic data and brought the body corporates, that means the private players, into the ambit of the law, right? So the genesis of digital privacy law. So before 2000, I would say it was not a privacy law, a digital privacy law. It was a privacy law protecting the individual's privacy against another individual or against the state. But as such, the jurisprudence of digital privacy law evolved for the first time with the IT Amendment Act in the year 2008. Then in the year 2011, we have SPDI rules. As I was telling you, it's a subordinated legislation enacted under or enforced under the IT Act, provides certain basic provisions in protecting the individual's privacy. It says that body corporate should have a basic privacy policy. It should publish in its website. It should obtain consent from the individuals before taking the personal data. Sensitive data, it listed down what are all the sensitive personal data. It said your password, your bank account details, right? Your biometric information, your health data, right? Your physical data, physiological data, mental data. All these informations were categorized as sensitive personal data, and therefore said that a special protection is to be given to these data while being collected by the companies, and also mandated the companies to implement necessary protective measures, security systems to protect this information. Then came RBI localization rules. This is a very important piece of very small notification, but very important from the point of view of cross-border transfer of digital data, because Reserve Bank of India, in order to protect the interest and in order to protect the privacy of the bank, consumers of the bank, said that no financial data can go out of India. So even as of today, no financial data can go out of India, because financial data is a very important and sensitive personal data, and it has to be protected. Even otherwise, from a leakage point of view, the Reserve Bank of India has prohibited any company from transferring the financial data from India to another country, right? Then came unsolicited commercial communication regulations, TRI. The Department of Telecom issued this unsolicited commercial communication. You receive so many spam emails, right? Marketing communications. You receive so many messages every day, right? Myntra is offering this, that, and all. Flipkart is coming up with this. How do you think it is sending you messages? You have given express consent to receive. If you have not given express consent to receive these messages, your continued usage or continued receipt of this message is an implied consent for the companies to send those kind of communications. Sending these unsolicited, you know what is unsolicited means? You have not asked for those informations to be sent to you, right? Sending these kind of unsolicited commercial communication is a direct violation on your privacy. If this happens in any other country like Singapore or US or Europe, the company is penalized the next day. I know for the fact that in a single day I receive at least 100 such commercial communications, because in India currently the enforcement is not so strict, but there is an infringement of my right to privacy on a daily basis, because I receive at least 100 of such unsolicited commercial communications. If you see every marketing email or a message that you receive, especially email, there is something called unsubscribe. How many of you have seen? Just raise your hand. Have you ever thought of unsubscribing to it, even though knowing that it is an irritating email that you receive every day? The moment you do that unsubscribing, they are not supposed to send you the next email communication to you. That means you have withdrawn your consent to receive that particular email or marketing communication. If they do it, you have every right to take action against them for violating your privacy right. Right? So there is a Department of Telecommunications unsolicited commercial communication regulations. You can go through it. You are a student of law. These are the new regulations which you need to be aware of and try to educate other people in enforcing their rights. Right? Similarly, even Internet Service Provider license. It also prescribes certain rules protecting the privacy of the individuals. Surveillance laws. How many of you are aware of the surveillance laws? We do not have a dedicated surveillance law, right? In India, we have one section under 4 of the Telegraph Act, governing the surveillance law of 1 billion people, right? Only one section, which is section 4 of Telegraph Act. That's all. And another section under IT Act, which is law on interception. These are the only 2 sections which talk about interception or surveillance on Indian citizens, which is a major threat against the privacy of the individuals. What is surveillance? Keeping a watch on you without your notice. Right? It is a direct hit on your privacy, but still we do not have a strict enforcement nor strict law on the surveillance of the citizens. In other countries like US, Singapore is what? Such a small country, but it has got a robust regulations, legal framework for protecting the privacy of the individuals. I will come to you why we are here, why these countries have such a robust regulations, right? Now after that we had an episode on data protection bill. I don't know how many of you are aware of it. India proposed to have its own codified data protection law, and an effort towards that started in the year 2017 with the appointment of Justice Shreekrishna Committee. A committee was formed in the year 2017 under the chairmanship of Justice Shreekrishna, who has been assigned the task of formulating a codified law protecting the privacy of the individuals, or framing the law on privacy for India. Right? Now, it first published a white paper giving the privacy and privacy regulations across the world and sought comments from the public. And subsequently, in the year 2019, it also released a report on data privacy, and subsequently it also released a draft bill of the data privacy law for India. Right? Now the same law, same draft with few modifications was subsequently introduced by then Law Minister to the Parliament, and based on the oppositions that received from the opposition party, it was referred to the Joint Parliamentary Committee, and Joint Parliamentary Committee took just 1.5 years to go through the draft and made 10 recommendations and 81 amendments to the draft. And you can understand what could be the reason behind it, right? It made 10 recommendations and 81 amendments to the draft, and it introduced even non-personal data into the ambit of the data privacy law. So it enlarged the scope of the data privacy to such an extent that later on, around in the month of August last year, the government withdrew the erstwhile PDP bill and said that it will introduce another bill. Now, just around 2 months back, it has now introduced another piece of draft, which is just around 32 pages, and now it is called as Digital Personal Data Protection Bill. So you can just connect the difference between erstwhile bill, which was withdrawn, was Personal Data Protection Bill, which was not limited to just digital data, personal data. Its ambit covered the entire gamut of personal data, whether it is digital personal data or physical personal data, or even it included even the non-personal data. Now, in the context of promoting the digital economy, now the government has introduced another bill called as Digital Personal Data Protection Bill, and it is expected to be introduced before the Parliament either today or tomorrow. It has submitted before the Supreme Court of India that it will be tabled before the Parliament in the second half of the budget session, which is expected to start from today or tomorrow, right? So you can keep a watch on it and understand when it is introduced. The draft has already been released by the government, but once it is tabled before the Parliament, there might be few changes. Please keep a watch on it, try to understand. Now, this particular law is a very simple, just 32 pages with very few sections, gives sweeping powers to the government to control the privacy. I will not get into too many details because there are many other aspects to be discussed, but keep a watch on it and try to understand the developments. Now, there are certain principles of protecting the privacy under the digital space, and let us try to understand few of them. First one is notice. What is notice? It says that the principle of notice under digital privacy law says that if a company wants to collect your personal data, it has to give a proper notice to you saying that I am collecting this and this information from you. That's what I said. Please read through the consent that you give. What they give is a notice. It is called as privacy statement, right? It is called as privacy statement. It will give you a privacy notice or a privacy statement, giving you the details of the information that they collect, for what purpose the information is getting used, where it is getting transferred, who are all the third parties to whom it is getting transferred to, where it is getting stored, how long it is getting stored, and how it is getting destroyed or deleted after the purpose is fulfilled, after the usage is done. So the company which collects your information is required to give all this information in the form of a notice called as privacy statement. Now the challenge is how many of you have gone through it, have read it, understood it, and then have given your consent based on the notice is something which remains to be a challenge in the digital space, because you want to access the facility or the benefit arising out of the digital system in a fraction of a second. In that, what you do, I click finished, then you are totally finished, right? Then consent. The consent is the same thing which I was telling you. Make sure that you give an informed consent. Don't give a blank consent. Give a informed consent. Giving an informed consent is very important, especially you being lawyers have to go through the terms, understand, and then give an informed consent. Then collection limitation. The principle of collection limitation says that the company which is collecting the information has to collect only that much of information which is required for the purpose for which it wants that information. Let's say that I need your information for you to give an injection. I am a healthcare company. I deal with cancer patients, right? What I need your doctor prescription. I need your medical history. Okay? So only these two things I want. I cannot ask you to give some other information which is totally unrelated to this. I cannot ask you to give your telephone bill, which is totally unrelated to the purpose for which I want to collect the data from you, right? So that is called as collection limitation principle of collection limitation. But there is a challenge in digital world, because I want to use your data for not only for an immediate purpose, but even okay, let us collect it. It may be useful for tomorrow. I want to start some other business vertical tomorrow, so it may be useful. So collecting information which is not relevant for the purpose is against the principle of limitation, and it remains to be a challenge in the digital space. Next one is purpose limitation. Again, I am telling you, it has to collect the information only for the purpose for which it is required. It is not that I take your information for you to give some financial services and then tomorrow use it for giving you marketing communications, right? If I have collected for giving financial services, I need to use it only for giving financial services. If I want to use the same data for giving some other services, I need to come back to you, inform you, take your consent, and then use it for marketing communication. But is it possible, practically possible in a digital world? It is not possible. But the law says you have to go back to the user, take a separate consent, and then give additional service. We just discussed in my company that you are okay to give transactional communications. You can send. That means if you have purchased a product from me, I can tell you that this is due for renewal. Okay, this is a transactional message. But if I can send you, take one more product, I will give you 10% discount. It's a communication. It's a marketing communication. If I send that marketing communication without your consent, then it is violating the privacy of the individual. Therefore, the principle of purpose limitation is a very important principle, and any violation of it leads to a serious consequences. But it is practically difficult for a company to implement it because of the challenges it poses. Next one is access and correction principle. It says that the user which has given the information should have access to the data in the system of the company. If I am a company has taken your information, I need to give an access to that information. I need to tell you where your data is stored, right? And if you think that the data that I have is not correct, it is accurate, while collecting the information, the data has become inaccurate. Instead of Shreekanth Katti, it has become Shreekanth some other thing. you have right to ask me to correct the data that I have. So that is the right that I should give you if I am collecting your data. If your telephone service provider has misspelled your data, or it has captured your name wrongly, or your father's name wrongly, you have every right to go back under the privacy law, because the principle clearly says that you have every right to go back, access the data, and also correct the data. Again, in a digital world, when the data traverses so many places, it is very difficult to correct the data in all those places. So these are the limitations that we have. Transparency. It is an obligation on the part of the company which collects the data to maintain transparency about the information that it collects. It has to be fair and transparent. It has to tell you what data I have collected, how it is being used, where it is being shared, where it is being stored, how it is getting protected, right? All those informations are to be given in a transparent manner to the user or the individual which has given the information. Then security. Is it in a digital world, in a scenario where the data is getting protected or saved in an online platform, it is impossible to say that there will not be any threat to the security of the information, right? There is a famous terminology called, it is not 100% foolproof, right? Your data is not 100% secure. If anybody is giving you that promise that your data is 100% secure, that's a false promise. It's a wrong information that I have given. It is a misrepresentation. You can actually sue him for giving you a misrepresented information. No data in an online space is 100% secure, right? But at the same time, the principle of security tells you that the company is obligated to implement reasonable security measures to protect the personal data. Now, under the Indian law, there are certain standards. ISO 27001, you must have heard about it, right? Indian Standard Organization, International Standard Organization, they have issued certain standards indicating the security measures to be implemented, and accordingly, those security measures have to be implemented by the companies which collect the personal data, and the principle of security tells about it. Now, the challenge is, let's say that you are a startup company. We are a startup hub, right? ISO 27001 for a company to implement will cost you minimum 10 to 15 lakh rupees. The funding of the startup company itself is 5-10 lakh rupees, right? Where will a startup company get that money to implement these security measures? So it is a challenge for a company, but it cannot say that I will not collect the personal data. These all fintech companies, right? Loan apps, what you see, they are all startup companies. They offer loans to students. I'm sure few of you must have availed those student loan issued by these fintech, finance act, right? Now they give loan to you, right? They collect what? Your PAN card, your Aadhaar card, everything they collect. Do you think that they have implemented necessary security practices? Unfortunately, I am a startup advisor to a couple of startup companies. I know that 90% of them have not implemented this ISO 27001. So most of the personal data that they have, which is a sensitive data, is not adequately protected as per the principles, right? So it is not protected as per the law. And last principle is accountability. That means in case there is a violation, the principle says that the company has to be accountable for that, right? Next one, please. So having understood a couple of things, it is very important to understand the cross-border flow of data, because as I was telling you, there is no geographical boundary in a digital space. You cannot say that in a digital space, Indian map look like this. There is no India, Pakistan, China. Because for data will not understand that I have to remain only in Indian boundary, because it's a digital data. I can send WeChat message which can go to China. I can send some other message which can go to even Pakistan, right? Therefore, when it comes to cross-border transfer of data, especially the personal data, one has to be very careful in analyzing the local regulations. Indian law, as I was telling you, the Reserve Bank of India prohibits any financial data of the bank consumers to be transferred outside India, right? For the protection of the individual's data as well as for protecting the economic interest of the country, the country-specific regulations on the cross-border transfer of data are to be complied with. Even in India, there are certain restrictions with respect to cross-border of data. Now, Indian law says that for certain informations, you can transfer the data, digital data to outside of India, which has ensured the same level of protection as that of India. Let's say if Indian company is required to implement ISO 27001, even let's say Singapore has implemented a similar ISO 27001, then you can transfer. This is called as adequacy test principle. Principle of adequacy. So that means if we have adequate measures implemented in both the countries, then you can transfer the data to outside that country, right? So similarly, US and EU had a privacy shield. You can just Google it and understand what is privacy shield. They had an understanding or agreement, separate to the the European law or the US law on data privacy to protect themselves from this cross-border transfer of the data, but subsequently it was held to be invalid. Currently, the European Union and the US are again negotiating to come up with a framework for the cross-border transfer of the data. As I was telling you, current Indian law restrict certain transfer of the data. For certain other type of information, it allows, provided it meets the adequacy test. Proposed digital data protection bill also imposes certain restrictions. It allows the cross-border data of the cross-border transfer of the data, provided the company which is transferring the data meets certain requirements and adheres to certain terms and conditions. In a digital space, cross-border transfer of the data is very important, because cross-border transfer of the data is very much essential if we have to operate in a digital world, but at the same time it poses the risk of privacy violation, because there is no control over the transfer of the data. So keeping in mind, the law has to balance between the business objective versus the protecting the privacy of the individual. Therefore, the cross-border transfer of the data becomes the epicenter of the entire privacy regulations. It has become an epicenter, and it will be an epicenter for all the privacy regulations to come even in the future, right? Next one. Okay, so these are all the various platforms in which the digital data may get transferred. I will just browse through it. You can subsequently try to understand. In e-commerce companies, then web and social media, I don't have to tell you. You browse through so many websites, so many social media platforms, smart electronics, phones, starting from your own phones. Every smart electronics, there is a digital personal data, security cameras, right? Hospitality and travel industries, employment. As an employee, we give a lot of personal data, banking and finance, e-governance, healthcare, educational institutions, telecom services. What is not left? Everywhere there is a digital data, and everywhere you are sharing your personal data. And therefore, every aspect of our life, starting from getting up in the morning till we go to the bed, every aspect is covered by digital world and by privacy aspect, right? Next one, please. This is the data life cycle. I have a lot to speak, but I am just skipping how the entire data life cycle management happens. First, the company creates and collects the data, then it uses and distributes, then it maintains, and then it finally disposes. Right? This is the entire, life cycle of the digital privacy data in a digital space. Right? Next one, please. Okay. Last slide. Right? Now, what has to happen yet is further deliberation of business versus privacy, right? If you see the digital personal data protection bill that has been released by the government now, the epicenter or the core objective of the law, generally if you take the European region's data privacy law, which is GDPR, Global Data Protection Regulations, right? The epicenter or the main objective of that GDPR is to protect the privacy of the individual. And if you see the current draft issued by the government, which is Digital Personal Data Protection Bill, it says that protecting the privacy of the individual in the context of promoting the digital economy. So the main objective of the government under this particular law is to promote the digital economy, and in that context it wants to ensure that the privacy of the individual is protected. Now there is one side, because without the data business cannot develop, right? Business cannot further strengthen. But for me to do business, I need the personal data. I need the data, and most of the data is personal data, and there is an impact on the privacy of the individual with that data. And another aspect is the protecting the individual's privacy itself. So there has to be a balance of convenience. As I was telling you, there is always a conflict between the business interest and the individual's privacy, and therefore there has to be a balance of convenience. Is it that I overweigh the business interest and not the individual's privacy, or is it that I overweigh the individual's privacy and not the business interest? Because for an economy to sustain, business development is required, but for me to have a peaceful life, my privacy is to be protected. That's what I was telling you, why Singapore has a robust regulation on data privacy, because it is already a developed country, okay, where it has reached a saturation when it comes to the business development. Okay, they can compromise or they can take a monetary hit when it comes to protecting the privacy of the individual. They are, for example, even the Germany company with which I am working, they give so much of importance to the privacy that they are ready to lose the business of millions of euros, but they don't want to compromise with the privacy of the individual. Even a single individual's privacy involved, they don't want to compromise. Can we say that as an Indian business house? No, it is difficult. If I am a pure businessman, if I am a startup founder, right, I cannot say that I am ready to lose business for $10 billion just for the sake of some 10 individuals' privacy. No, I am sorry. As a lawyer, I should not be saying that. But as a businessman, I need to overweigh what is important for me. And same logic goes to the entire country itself, right? Now, India, unfortunately, not in a position to lose business to the crores of crores in the context of overweighing the privacy of the individual, right? So that is where we are now. And accordingly, the Indian government is developing the jurisprudence on data privacy law in India. So jurisprudence, sir can tell how jurisprudence of a particular law evolves and develops. He can speak for hours together. It is influenced by many factors. One of such factors is an economic factor, right? And that is where we are now. And I'm telling you, the jurisprudence on data privacy in India is still evolving. We do not know where it reaches. As I was telling you, currently it is in the stage of weighing between the economic interest and protecting the privacy of the individual. Tomorrow, similar to the developed countries like Singapore, European region or US, it may tell that no, I would like to now overweigh the individual's privacy because we have reached the saturation in terms of business development. We have reached a stage where we can say that I am ready to lose business, I am ready to lose millions of worth of value, but I want to protect the privacy of the individual, right? When India reaches that stage, we will have a complete shift in the approach that we have towards the privacy regulation. But for that to happen, it is going to take time. Until then, the expectation from practitioners like me are that yes, you have some sort of a legislation which gives lot of flexibility for the companies as well as for the companies to tweak the law to suit your requirements. But make sure that you have sufficient enforcement mechanism. You may have a robust law, you may have an efficient law, but if you do not enforce it properly, there is no use of having a good law, right? How do you say whether it is a good law or not? Not just because it has got good contents, but I will say it is a good law only when it is enforced adequately, when it is enforced properly. And therefore, what is required even at the stage of bill, and we are all hoping as a lawyer, as an advisor for a company as well as a practitioner, is to have a good law as well as efficient enforcement of that particular piece of legislation. So currently we all have to wait and watch. If you are aspiring to be a privacy professional, you are going to have an amazing time, I am telling you, because it is a demanding profession. It will evolve, the law will just evolve, it will not reach a particular stage. If you take criminal jurisprudence, civil jurisprudence, there is no further development, but privacy law jurisprudence, it is evolving, it is going to evolve for next 20 years. After that it may stop. Then the practice, the actual practice of privacy professional starts. So if you want to be, or if you are aspiring to be a privacy lawyer, keep an eye, take a note of every day's development that happens, not only in India, but across the globe, because for a privacy law practitioner, you have to be a global lawyer. You cannot be just an Indian lawyer. Okay? You have to be an international lawyer. Then only you can practice this law thoroughly. Keep an eye on it. And then let's see where do we stand in terms of privacy versus digital world. Thank you so much. Thank you for your time.